Good morning, everyone, and welcome to February's Property Pulse webinar. It's so fantastic to have everybody. I see everybody's still getting on. I hope you have a warm cup of coffee. And I hope that you have the time and you have a pen and book with you. Today is going to be an absolutely great event. A couple of shout outs, please. You're welcome in the chat to say where you are from, saying hello. I'm quickly scrolling past. I want to say morning to Bevan. They're from KZN. I want to say hello to the RealNet group. I see you guys there. I see the Rawson people there. Oh, also always nice to see you. And let me see, Aldo Properties. Please do the shout out. It's always great to hear from all of you. We don't always speak, or when we speak, there's always problems. So it's always nice to speak to someone when there's not a problem. Rent a property. You guys are also chilling like us. Here in Gauteng is nice and rainy, and it's cold. We're not quite ready for the winter. Rentals.com, West Rand, Nikki and team. So great to see you all. Thank you for joining us this morning. Yes, we know you by name. Our clients are important to us. And we love to work with everyone. If we see the faces, we learn from each other. Now, this morning, I'm so glad to see we have so many people joining us. We are jumping very quickly. And if it needs be, we're just going to have to upgrade to be able to take more participants. What we have this morning is the big thing that I think is giving us a bit of a headache. And we see a lot of disputes coming in, and is what happens if the landlord does not maintain the property. But of course, Expeller is only as strong as our awesome panel attorneys. And the person joining us today as our guest speaker is Ishmael Mohammed, and he's from MML Incorporated and Mohammed and Leon Incorporated. They're in Cape Town, and they have done a lot of eviction files, and they have so much knowledge. Ishmael's always on top of it. He's always in the mix. He's doing the groundwork. He and his team is fantastic. So I want to say thank you and welcome to Ishmael. Thank you for joining.
Good morning, everybody. Elise, thank you very much for that introduction, and thank you for having me this morning.
Fantastic. I know you're a very busy man, so we are going to really jump into it. What we have is we are going to have Zelda in the background. So if you, if everything is there, if there's a question, please ask on the chat, and Zala will interrupt us if it's pressing. I will always glance at the questions as well, but we also will make a bit of time for a Q&A. What I always say to people, I've never been a clock watcher. That's one of the worst. I've just not been able to do that. So if we're done in 40 minutes, then that's the webinar. If we go over 5 minutes or 10 minutes, that it is, as long as we get value. So let's jump into it. Now, Ishmael, like I said, we get a lot of disputes. And in my mind, it almost feels to that if the landlord just keeps to their obligations, a lot of these disputes is not going to happen. Is the landlord obliged to attend to maintenance, Ishmael?
Okay, let's get straight into it. Is the landlord obliged to attend to maintenance? The short answer is yes. Okay, webinar's over. Thank you, everybody. Goodbye. No, okay. Seriously. Is the landlord obliged to attend to maintenance? Yes, definitely the landlord is obliged. But there are some exceptions to this.
Okay.
Now, what I've noticed, the questions that I get, the queries that get raised with me quite often, don't really surround maintenance, but they surround improvements or
Okay.
something that the tenant may deem to be maintenance or necessary. Now, we have to make that distinction. So the general rule of thumb, excuse me, the general rule of thumb that we use is the premises habitable, right? Now, habitable has, in some versions, an objective view, and in other versions, it's got a subjective view. Now, we've got to make that distinction as well. Now, what I mean by that is, if a tenant takes occupation, they view the premises, it's fine, it's, 2-bedroom, ground floor, whatever the case may be, and they are happy. And the geyser's working, the lights are working, there's no infestation, there's no mold, there's no nut. Everything's fine. Then there's continuous maintenance that becomes necessary as things start to wear and tear. We'll get to that term later if there's time, right? But what will often happen is tenants will then come forward and tenants will say, but I need, for example, a security gate because there was a break-in 3 doors down 2 nights ago. Now,
Yeah.
Mr. Landlord, you need to do this. This is maintenance. You need to do this for me. No, the landlord doesn't have to do that. The landlord can choose to do that, absolutely nothing wrong, but the landlord doesn't have to do it because the lease doesn't include that item. So to do that then becomes an improvement. But if the premises had been viewed with a security gate and something happened to that gate and that gate's now fallen off, then that falls under maintenance because it's pre-existing already. So we've got to make that distinction. So as I say, general rule, yes, the landlord needs to do maintenance, but there's always exceptions. And it's not a broad stroke of just, yes, all maintenance must always be done, and that's just the way that it is.
Yeah.
You have to look at it on a case-by-case basis and say, is this necessary? Is this my responsibility? And what needs to happen go forward? So I think that kind of touches
That
into our second question as well, and our third.
Yeah, I think that's so valuable. And I mean, I think you touch on something that I sometimes forget. I mean, the fact that you just need something, and we usually go to the extreme. Eh? We have tenants going, "Oh, you need to change the painting on the walls against my order," which is absolutely nonsense.
Yeah,
But
indeed.
but to change that makes a big difference. But now, of course, we get to the thing and we say, okay, there's maintenance that needs to happen. I mean, a geyser, a security gate that was there that's now suddenly broken, which needs to be fixed. It has to be fixed. But by when? Because, it's not like those people going, yes, 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 I'll do it. And then it never happens and it escalates. What guidance do we have here? And I know you're going to throw a cat between the pigeons a bit.
Okay, so the guidance we use here is always as soon as possible. Your maintenance must be dealt with as soon as possible because we've got to remember this is a contract between two parties, two completely independent parties. You've got your landlord, who's the owner of the property, and you've got your tenant who has occupation of this property. Now, why does the tenant have occupation? Because the tenant is paying rental. Now we've got to ask ourselves, what is the tenant paying for? The tenant is not, it's not simply a case of saying, I'm paying for the right to occupy the premises. You've got to be saying, I'm paying for the premises as it is, as I expect it to be in terms of my lease. Again, not expected to be because my previous landlord gave me a swimming pool and now you have to go and put in a swimming pool for me. You know,
Yeah.
it's what was viewed, what was agreed upon, what was signed into existence on the signature of this lease.
Yeah.
If that's the case, now let's take the geyser, for example. This is quite a common one, right? Fortunately, I've noticed that I haven't had too many issues when it comes to the consequences of a geyser because people accept this is something that happens.
Mm.
You know, a geyser is going to go from time to time. It happens in everybody's house. It's just one of those things. And if it happens on a Monday, the tenant's got to call the landlord or the agent and say, this has happened, this needs to be attended to. The landlord doesn't get to sit back and say, well, I'm not in the mood for this today because it's Monday and I haven't had my coffee yet. He's got to be on the phone. He's got to be calling up the insurers and he's got to be saying, I've got this issue. This has come up. When are you coming out?
Mm.
And then the process will there follow after. So you're going to have somebody come out and inspect it. You're going to have the insurance claim put in. You're going to have the work done. This might take a week.
Mm.
I find that tenants are generally understanding to this. This is
Yeah.
something that takes a week because it might have happened to them before. It might have, done it in their houses before they started renting, whatever the case may be. So this is something people are quite understanding in. However, that doesn't allow our landlord to say, well, I'll get to it next month. He should just understand that these things happen. It comes down to what is as soon as possible and what is reasonable. Again, if it's a security gate, yes, it needs to be dealt with now. If, however, it's a storeroom that nobody ever goes into because, the tenant said, well, I put my things in there and I don't even know what's in the storeroom. I haven't been there in so long.
Yeah.
But the window's starting to rust or the window's starting to be a bit loose. But the window's too small for anybody to climb in. And it's the middle of summer, so there's no rain.
Yeah.
There's not as much urgency to it. But again, as soon as possible. So we've got to consider what is reasonable and what can we do. Of
Yeah.
course, there's the other curveball where we enter into leases, and in the lease we say landlord will attend to the following. And then the landlord says, oh, I'll do it before they leave.
Yeah.
No, you've got to do it now because it sort of becomes a condition of your lease. So
Yeah.
again, we always come back to what is reasonable and what, in my view, is as soon as possible. Because we cannot be saying to our tenant, you are leasing this from us, but I'm not giving you 100% of what you are leasing. I'm
Yeah.
giving you 80% because you are not able to access the swimming pool, the storeroom, the third bedroom, whatever the case may be. It's no
Yeah.
different to the landlord or the tenant saying, I'm going to pay you 75% of the rent. I've got 100% usage of the place, but I'm going to give you 75% of the rent because I'm not in the mood and I can't be bothered to pay the other 25%. It's a breach on both sides. What are
Yeah.
we paying for? What are we offering? What was agreed on? And that's
You're
sort of
saying,
our rule of thumb.
I have to say, you're touching on two things that jumps to my head. And King Price suddenly jumps into my head. And the fact that if people don't maintain the property, and I mean, at the end of the year, people always want to increase in the rent. And if there's been no maintenance and the property
Mm,
is not in the same, and I'm not talking just about fair wear and tear, I'm talking about, those major things that get broken, the mold. I mean, mold is
mm,
a problem everywhere.
mm,
You've got a new cousin mold that moved in. I mean, then they want an increase. I think people sort of get that as what am I renting for? So that
mm,
jumped into my head, and we're going to touch on that just now. And I think it also, what you said, it sort of flows in very well to the next one. And I often see this where people go into a property, they do the inspection list, noting things.
mm,
And then they say, okay, well, there was a crack on the corner tile.
mm,
It's been noted. The purpose of it being noted was to say, listen, we're not going to hold you liable for the tile, but it doesn't per se mean it needs to be fixed.
mm,
So definitely it should be clear as to if there's anything specifically, like you said, what should be fixed and what should not, and by when. I think
mm,
that's the other thing. I think a lot of disputes don't assume, because I hear often, like you said, the landlord says, well, I'll do it before they move out. The tenant, I had it in my mind, he's going to fix it in the next 2 weeks.
Hmm.
So I think if there's certain things that has to be fixed, I mean, write it in. This needs to be
Hmm.
fixed within the first 3 months, and or 6 months, or it doesn't need to be fixed. We're purely noting it. If there's a big thing, ideally the landlord should, because they want to keep their property in a good condition. Not so.
Indeed. You see, what we also need to understand is essentially 90, well, not even, I'd say 100% of all rentals
Yeah.
is a case of a tenant renting secondhand goods. Because it's not, you haven't bought this place from a developer who's just built it and now it's brand new.
Yeah.
Even if you are renting from the owner who bought it brand new, it's still secondhand to you because it's the owner's first,
Yeah.
right? So just on that, you have to accept that it's not going to be in pristine condition. Nothing is ever going to be in pristine condition. I'm not saying it needs to be in terrible condition. In fact, we don't want it to be in terrible condition because we want to be able to find good tenants. And a good tenant is not going to take something in a terrible condition. But as you
Yeah.
say, the lease is signed and there's an inspection that gets done and there'll be a walkthrough and they'll note certain things. That is not to say the landlord needs to repair these things. As you
Yeah.
correctly say, Elise, this is noting so that the tenant is not held liable for these things. More to that, there is, in most leases, there's then also a bit of a window period, maybe 7 days, that the tenant's now in occupation, that the tenant can then come forward and say, oh, well, while I've been living here, I've noticed the following. Maybe the garden tap doesn't work. Maybe there's a crack in the second bedroom tile that we didn't notice on the initial inspection. So now we've got to weigh those two things up. The tile is not going to be repaired, but thank you for bringing it to our attention. We'll not charge you for that tile. The garden tap, however, our lease says you are responsible for the garden, but we haven't given you a tap for the garden because the tap's not working.
Yeah.
That then falls onto maintenance as soon as possible. Because again, if we don't fix the tap, the tenant gets to say, well, I couldn't water the lawn. You never maintained your tap. So, there goes your lawn. And now the fight starts. The lawn's died. The tenant's moved out. Do we take it off the deposit? Do we not take it off the deposit? What happens? So
Yeah.
from that side, we as landlords or agents need to protect our investment or our business by saying clearly to all parties, this is maintenance. Why is it maintenance? Because it's necessary for the occupation. A crack in the wall or a crack in the tile is not necessary for occupation. It's not deemed maintenance. The tap in the yard that feeds the lawn is maintenance. Versus, there's absolutely nothing wrong with the tap. When the tenant leaves, we find the tap's been pulled out of the wall. That's not maintenance. That's beyond wear and tear damages. So it's lines in both directions, and we've got
Somebody
to
taking
be knowledgeable to
yeah,
find
somebody
where we cross
taking
these lines.
somebody taking gardening very, very serious.
Yes, exactly. Well, I've
Like,
I've had my 7-year-old pull a tap out a few times because it just tugs on that pipe, and I'm like, okay, no more gardening for you, my boy. No more gardening for you.
this was, in a sense, still the easy part, because I think we all know the obligation is there. I mean, if you look at the Rental Housing Act, it says you have to maintain the property.
Hmm.
But I think where we get into the more difficult part, and I actually saw one of the comments now, and we're going to touch on it, is what if the repairs isn't done? And that's for various reasons. It can be either, I see in the comments, my landlord is just not coming back to me. We've been asking, we've been requesting, and they just ignoring us, hoping that we go away. Or whether it is that the landlord might not have the money. So if the tenant, I mean, the tenant has put through the request, and on many occasions more than once. And I trust all the agents has now conveyed the message to the landlord and told the landlord about this. And now there's a deadlock. Either your landlord can't or refuses, or it's just ignoring you. What should then happen?
Okay, so the first thing that we need to touch on here is what is the responsibility of the agent? Because this is obviously very important, especially for our discussion here now.
Yes.
Because a large part of this has to do with how do we protect the agency or the agent, because there are grounds for liability that comes into this, right? But we'll touch on that now. So remember, your relationship with your landlord comes down to your mandate. Now, I haven't seen everybody's mandate that's on the course this morning, but I've seen many, many mandates. Some mandates, which I'm in favor of, make provision for the agent to do certain repairs without the landlord giving him the go-ahead. So what they'd put a figure onto that. They would say 1,500 rand, for example. Or they would say emergency maintenance. The agent has full details of who the insurers are in the event of a geyser bursting or anything along those lines. So that does clear things up a bit, because then the agent can say, I've got this query from the tenant. I sent somebody out to go and check. There is indeed an issue. The issue is going to cost 1,000 rand to fix. I'm going to fix it. Comes from the rental. So that clears the landlord's responsibility. It protects the agent, keeps the tenant happy. But at the end of the day, the landlord's paying for that because it's coming from the rental.
Yeah.
Now, if your mandate doesn't allow you to do that, if the mandate is silent on the agent having the ability to do maintenance without consent, then you must not do any maintenance. Because the second you do maintenance, if that's coming out of your pocket, your landlords get to say, I never authorized that. I want my rental at the end of the month. And you've now got to go and fight about that. And chances are you're probably going to lose. So don't go down that road. So if your mandate makes provision, but the repair is more expensive than what the mandate allows, if your mandate is silent, do not do the maintenance without your landlord's consent. Now, you get the query, you send it to the landlord. The landlord is either silent or the landlord says no. But it's clearly an issue that is for the tenant, for the landlord. There might be a burst pipe. And that burst pipe is leaking water somewhere in the garden. Not something the tenant could have had access to, not at the tap, it's completely underground, so it's not a fair wear and tear issue. This is a maintenance issue. The landlord doesn't come forward. Now we've got to look at who is responsible and in what way. This is no different to a breach by the tenant. Remember, if the tenant doesn't pay, we put them in breach, we may cancel the lease or take other action, issue summons and so on and so on.
Yeah.
If the landlord does not do necessary maintenance, the landlord is in breach. As I touched on earlier, what are we leasing to the tenant? It's not just the right to access, it's also what that access allows. Water or access to water. Yes, they've got to pay the bill at the end of the month, but they must have access to water. Electricity, swimming pool, 3 bedrooms, double garage, electric gate. These are all things that the tenant is paying for. That's why they're paying the rental, whatever the amount is. As soon as we cut one of that off, we're only giving them 70, 80, 90% or 20% of what they're actually leasing from us. And the tenant is then allowed to put the landlord in breach. And the tenant can say, I'm giving you X amount of time to correct this issue. So now let's consider that. our lease agreements don't necessarily make provision for this. Some do, some don't. Because some leases will say if either party is in breach, the other party may. And then the procedure follows thereafter. While many leases say if the tenant is in breach, the landlord may, which means it's not the same process necessarily, or not the same timelines, but the process remains the same. The tenant may send a notice to the landlord and say, there's a leak in the garden and the water pressure has disappeared and this account is running through the roof. That can be deemed sort of necessary and emergency. And so I'm giving you 24 hours to sort this out. If not, I'm going to cancel the lease and I'm going to leave, or I'm going to sort the issue out and I'm taking it off the rent. And I know the leases say no deductions, no set off, none of that. But we've got to remember, your lease is subservient to the Consumer Protection Act. Your tenant is a consumer. Your landlord is a supplier. And in the Consumer Protection Act, you have the right to repair, refund, or I forgot the other one suddenly. Yes, the R and R.
Repair, refund.
Repair,
Cancel.
refund, replace.
What?
Sorry, repair, refund. I never think of replace because when it comes to immovable property, you're not really replacing.
Yeah.
So, repair, refund. Those are the two that we are dealing with. The refund can come off the rental. The repair comes off the rental. Because again, Consumer Protection Act, very strange that it applies to immovable rentals, but it does. So we have to adapt it to how it works there. So again, you can send a note, or your tenant can send a notice of breach. They place the landlord in breach. You must step up. You must do what's necessary. If they choose not to, then they can cancel the lease. They can deduct it from the rent. And as it says on the screen, they can go to the tribunal. We don't want to be before the tribunal on something like this. If it's a necessary repair, the tribunal is going to make an order in favor of the tenant, and more than likely, it's going to be a harsher order than had the work just been done. So never think, I'm just going to leave it. It will be fine. Again, where the danger comes to the agents is...
So Ishmael, before we jump into the danger of the agent, and we're going to specifically look at the agent's role just now, and where it really becomes difficult, in between. But just with the tenant, and I think you said it so nicely now, is they have to look at what is the right, and they have to follow the correct process. So the question everybody always asks is, so may they just withhold the rent? And what you said now is, no, there has to be a process that has to be in place. It's the same thing as we can't just evict someone. We need to follow the process. We need to follow the correct demand, cancel, then we can evict. Or would have liked to evict maybe just immediately, but you can't. Same thing with the tenants. You can't just go and withhold the rent. You need to do this. But I think, and that's where we're going to go to the next steps where you wanted to touch on, is when we get to the agents. Because I mean it's difficult with an agent. So we for the landlord, but we don't want to step on toes. So how do we now deal with this?
Okay, so let's just take one quick step back. I just want to retouch on what I mentioned and what you then followed up on again. So what happens in some circumstances, and we've seen this so many times. So I've been in touch with an agent, or I've been in touch with Expello, and they say, we've got a tenant who hasn't paid 1-2 months rental. We send the letter of demand, we do the notice of cancellation, we start the eviction process, we get into court. And when we're standing in court, the tenant walks in and says, but they never did maintenance. We're like, what are you talking about? We say, well, he never did this, or he never did that. It's like, have you informed us of this? Have you spoken to the agent? Have you spoken to the tenant? Have you spoken to Expello? They say, no, but that's why I didn't pay the rent. That's not a defense. That is not a defense that concerns me, because I get to say, well, you're bringing it up now, but you haven't given my client an opportunity to rectify his breach if he was in breach. You never informed him of what was happening. The fact that you were in occupation means you're the only one who knows what's happening in the property. In fact, I had one particular case where there was a water line that had been broken in some way or the other, probably just through corrosion, and the water started bubbling out. The tenant said nothing. For an entire month, the tenant said nothing. At the end of the month, the tenant dug down, repaired the pipe, and closed the hole. When the water account came at the end of that month, obviously everyone's shocked because now it's multiple thousands of rands in water that's just run away. The account gets given to the tenant and he says, no, it was a leak. It was a leak and therefore I don't have to pay it. You have to pay it, you the landlord. But again, my argument, which was successful against the tenant, was, but had you informed us at the beginning of the month when this happened, we would have sent someone out and stopped the damage. The fact that you sat on it for a month and allowed this damage to continue makes you liable. And we held him liable and we were successful in that. But you see, so the tenant doesn't get to just raise this later.
But
If
Ishmael,
it happens, yeah, sorry.
No, I don't know if we're going to say the same thing. As in, I wanted to say, what would the picture be like if the tenant actually raised it a couple of times? It kept on saying, I mean, with the Expeller side, we actually had a few matters where it was quite evident from various correspondence that the landlord has been reported for more than 3 months, and that it's just being ignored. Will the view be a bit different in court?
The view will be completely different then, because then we're saying, so now we've got an agent, we've got a tenant saying, I have this issue. The issues come up, the issues come up, the issues come up. The landlord is not attending to the issue. Now the tenant, but now again, a fine line, if the tenant simply withholds the rent, because let's say, for example, the swimming pool. The pump on the swimming pool has packed up. This is a landlord issue. I know some leases make it a tenant issue, but let's just work on the assumption this is a landlord issue. The pump has packed up, the landlord won't attend to it. And now the tenant withholds 3 months worth of rent. So we've got a 20,000 Rand a month rent and we've got a 4,000 Rand pump. It doesn't balance. That will be against the tenant. Had the tenant said, I took 4,000, fixed the pump, and I've paid you all the other rental, then your landlord doesn't get to demand and cancel based on that 4,000 Rand. So there has to be a balance. The actual damage suffered by the tenant, what the tenant has lost or what the tenant has spent, that he gets to withhold. He doesn't simply get to hold the rental as a ransom. That doesn't work. Okay, so I just wanted to touch on that. I think we can move to the next slide now.
Okay, but thank you. I mean, that is clear because very often we say from Expeller side that, listen, if there's an issue and the tenant has pushed that process, and often what we see is that some of the maintenance has grown so big because it hasn't been attended to timeously. It's becoming more than the monthly rent, and it just blows up. And then it sort of comes down to, but you can say to a tenant, listen, please go read your lease agreement and follow the process. But can an agent say, well, listen, we received your request. It's almost like I always say to my landlords, you've asked for the rent, but you didn't demand it. So there's a difference. Tenant, listen, we got your request. It has been handled. It's not being attended to. So please follow the next step. And the next step is a letter of demand. May agent tell the tenant, listen, give me a letter of demand?
Can the tenant ask the landlord?
No,
can the tenant ask the agent for?
Can the agent say, listen, send me a letter of demand?
No.
and
the agent cannot do that. Remember, as the agent, you are mandated by the landlord. The landlord is your client. Now, in in commercial terms, let's talk it in business terms. You have a landlord and you have an agent. Now, the word agent is simply used as a title to describe. I'm the agent. I market properties, I sell properties, I lease properties. I am the agent. So in general use, this word has just been thrown around. But remember, legally, this word holds status. You have your principal and you have your agent. Your principal is your landlord. The agent is your property practitioner. You legally step into the shoes of the principal as far as your mandate allows. So the law, again, as far as the mandate allows, the law does not make a distinction between the landlord and the agent, which means the agent cannot say to the tenant, do this against my landlord. Because you're saying, do this against me. Because I am stepping into the shoes of the landlord. So the agent should not be saying to the tenant, send me a letter of demand so that we can get this ball rolling. That's not how it works. What the agent can be saying is, excuse me, what the agent can be saying is, you have to follow the process. The lease will set out the process. But there's no giving them precedent letters and sending them emails and saying, send me a letter, I'm not going to attend to it without a letter of demand, and hinting them towards a letter of demand. We do not give legal advice to the other side. As much as we might have a good relationship with this tenant and we might like this tenant, we work for the landlord. We protect the landlord's interest.
Ishmael, just on one note, and there's something that in my mind is that if we say to a tenant, listen, please follow the correct process. And the correct process would be technically you have to formally demand that whatever you need us to do. In my mind, and please guide me here, is I feel that an agent can actually say to them over and above to say, please follow the process. Because what we see is if we tell them just follow the process and they don't send a demand, I'm not talking about the content as yet, then it keeps on saying, well, you didn't follow the process, and the whole thing just escalates. Where in my mind, it's purely a process flow. To say to a tenant, listen, I hear you are upset. You feel you are not being, your matter hasn't been attended to. Please go look at clause so-and-so from your lease agreement. That's how it's going to deal with the breach. So before we don't get a formal demand, this matter is not going to go any further. Is that wrong? Can one say this? I definitely agree with you to say, listen, you're not going to tell a tenant, please, in the demand, I need this, this, and this, or the defects. But we can touch on that just now as well.
Yeah, so I'm with you. I understand where you're coming from, where you are saying you're going a little bit further than follow the process. That's fine. But be careful how far you go. You cannot be giving advices to the tenant. Not when those advices are processes against your landlord. So saying, go and look at the lease, go and follow the process, it's set out in there, that's fine. What we also have to remember is if a tenant sends an email and the email says, you need to attend to this, that's a demand. If the email says, please can you have a look at this, that's a request. So
I love that.
Again, we're not necessarily giving them the wording. We're not allowed to give them the wording. But every email is not a request. Elise, you and I and many of our agents, we know what terms to use for the court to say this is acceptable on a first reading. But again, what is a demand? A demand is when I say you must do something. Okay, we embellish it with all our legal terms and we make it look all scary and all of that. But if the tenant says, you must attend to this, that is a demand. and your process has started. So it's as to say, it's a very fine line between what we are saying to the tenant and what the tenant's going to do. But tenants more than often will fall over the necessary line and be able to send that notice out without even knowing that it counts as a proper notice. They hope it does, and then it does. I mean, I've had many, many cases from the other side where landlords have sent emails to tenants about vacating and about, paying the rental. And I will say to them, okay, send me your communication. Because if I can read that communication and say, it works, I don't send a demand. I don't send a cancellation. I go to those emails and I say, the landlord said, be out at the end of next month. He just by sheer chance gave him the correct amount of time, and we work on that. Same thing here. Your tenant by sheer chance, or not even chance, by just saying, I want this attended to. It's no different to walking into a Vida and saying, I want a Americano. It's a demand, one that I pay for, but it's still a demand. So,
but I love this, Ishmael, and you just reminded us, just because it doesn't say letter of demand doesn't mean it's not a demand. And I think that's where you confuse it. I want you to actually convey this. If you get an email from a tenant saying, you have to fix this within the next week, or I'll do this, that's a demand.
That's a
and you should
demand.
actually tell your landlord, listen, it's been demanded. Yeah,
Yes.
without it doesn't have to give the heading. I think we've all been so used to labeling everything. But
Yes.
like you say, just because you take off the labels, the content is still going to be the same.
The content's still there.
Use it.
The content remains, and that's where your process starts.
Yeah.
So again, looking at your first, may the agent ask the tenant for a letter of demand? No, he may not ask it, please send me a demand. But you are saying, you can say to your tenant, I need something in writing.
Yeah.
That you can say, I need something in writing, because again, having something in writing not only allows the process to start, but it also protects you as the agent to say, on this day, I got the demand. This is the day that they sent me the demand. So they sent it to me at 9:42 on the 19th of February. And I forwarded to the landlord at 9:44 on the 19th of February.
Yeah.
So, so you as the agent are now protected, because let's just go straight to the third point here. What should the agent be careful of? One, be careful of giving advice to the tenant. Don't go over that line. Don't say, here's a letter, just sign this and I'll send it to the tenant, or to the landlord. Not allowed. Can the agent write a letter to the landlord and say, you have not attended to this maintenance. You are demanded to attend to this maintenance. Now remember, I'm saying this is the agent writing this letter. No. You don't work for the tenant. You work for the landlord. If you do that, you're in breach of your mandate. Okay. If you, however, take the communication from the tenant and the communication says, we give you 3 days to repair this, and you send that communication to your landlord on the 3rd day, no time to repair. Now it lapses. Now the agent takes action. And your landlord now says, I didn't have time. I only got it on the 3rd day. I would have attended to it. I'm trying to attend to it. You as the agent, you become liable because you did not fulfill your mandate. You did not fulfill your role. You should have communicated as soon as possible. Or not even as soon as possible. You should have communicated immediately. So again, if you get a phone call, it's hard to prove I got the phone call on this date and I made the phone call on that date. But if you've got it in writing, you've got your paper trail. I received it at 9:42. I sent it off at 9:44. Your landlord still has his 3 days. So you protect yourself, you protect your agency. Because at the end of the day, the fight is between them. You've got a
And that's
side you need to take, but the fight's between them. So
and you say it
be
so
careful when.
nicely. Ishmael, you say it so nicely. And just to ask, because I mean, with these days, everything is on WhatsApp. Okay? WhatsApp is
Mm.
like the ring word. If you get that notification or that request or anything via WhatsApp, does that count?
It does count. It does count because you've got to look at how were you communicating with this tenant. Because unfortunately, the tenant is not held to the same standard that we are. If we've got a lease, and again, this grinds my bones, my staff are so tired of me saying this. It's 2025. Why are we still finding leases signed in the last year, 2 years, 3 years, that do not set out email addresses for the tenants? How are we supposed to communicate with these people? We cannot use the post office. The post office died 5 years ago. It does no longer exist. So if your lease sets out phone numbers that you may send correspondence to, then we can send notices via that number, via WhatsApp, via text, via whatever to our tenant.
Mm.
But if it doesn't set out the phone number, then we can't really use that unless we can prove it was received. However, if the agent and the tenant are speaking on WhatsApp through the lease,
Yeah.
and the tenant then sends something on WhatsApp, you have to fix this. The court will accept that because the court will say you tacitly agreed to this. Because again, the tenant is held to a lower standard than we are. With us, with the landlord, with the attorneys, with the agents, the
Yeah.
court will say, I don't see this phone number on the lease. But with the tenant, they'll say, but that's your phone number. That's how you communicate with all of your agents or with all of your tenants.
Yeah.
It's more of a business. You're unlikely to change your number. Your phone's probably going to be on, but with all agents, your phone's at 3% because you're on it all day. But that's how you communicate. So yes, WhatsApp will be accepted, and you've got to send that message on to your landlord immediately. Do not delay. Cover yourselves.
This
Okay.
that is so important, Ishmael, and I think because communication these days, I think WhatsApp is being deemed as almost as email. I mean, if I see what
Correct.
we sending letters via WhatsApp these days because people read their WhatsApps, not their email,
Correct.
and so that does jump up every now and again. The other thing that I want to ask and guidance here, and I think this is one of the frustration because I also see this because now the tenant gets upset. The landlord is not attending to what they're supposed to do. Say, for example, this is the scenario. Agent says to the landlord, you need to fix I don't know, let's pick the security gate. You need to fix it. It was there. It was broken in. You have to fix it. And they're just not attending to it. Let's say worst case scenario, there wasn't even insurance, so the landlord had to pay it. And the landlord is just not going over to action. Then the tenant is starting to jump up and down. And as an agent, I often see, the tenant usually takes the agent to the tribunal or they bad mouth the agency. And I mean, a lot of agents spend a lot of time on their branding to have a good professional awareness. And now the tenant goes and say, oh, this agency doesn't attend. It's never the landlord, it's always the agent, hey? Where does the tenant from your side, does the agent make a call and say to the tenant, listen, firstly, I cannot act on something, it's not my property. The landlord doesn't attend to it's not me. Or do you purely have a conversation and say with your landlord, either you attend to it or I cannot work this way and I end my mandate. I mean, where do you sort of get if you don't have if your landlord is really just not cooperating? Is it really you decide which punch are you going to take?
Yes. Look, it's a commercial decision that the agent needs to make. But in my view, is the agent able to then say, you're not coming to the party. This tenant is suffering for something that they should not be suffering on. This is a valid repair that needs to be done. You're not doing it. You're not giving me the authority to do it. I'm going to cancel my mandate. Yes, because again, there is a contract in place. The landlord is in breach of that contract. The landlord, through that breach, is harming the agent. And the agent is then able to say, I'm not going to be involved in this. This does not suit my business. We do not work unlawfully. We do everything properly and professionally. And due to that, I'm out. And your landlord, your agent is able to walk away from that mandate due to that.
Yeah.
Often, though, what I find is it's usually your biggest landlord that does this to you, which again, as I say, becomes a commercial decision as to what you are going to do. But that unfortunate decision your agent's going to have to make.
Listen, I had a conversation with one of the tenants and I said to him, let's make peace with it. You are unhappy. The landlord is not going to fix it. You're not going to sue him. So the only thing that's left is please vacate. Because this is where we're at. And the sad part is that landlord is not going to attend to it and they're going to basically just go and lease it out to a new person in any event. I think while we were talking, we touched on many of the questions that popped up. I just want to read the last one. Okay, so I think I'm going to read Aloma's message because it's twofold. So I don't just want to summarize it. It says, is an agency legally allowed to withhold paying rent over to the landlord should the landlord not have supplied all legal documents to an agency for the lease agreement? Okay, wait. Aloma, that question is not related to the fact that we're addressing today. We are going to address those type of things at a seminar next time. So we are not going to answer it. I want to stick to topic. And that's how I know we're having fun. An hour goes past so quickly.
We've got 8 minutes left.
8 minutes left. I think from my side, or Ishmael, what is your last word that you want to share with agents that they should, I mean, you see all of these disputes, advice that can make their lives a bit easier?
The best advice in a situation like this, look at your mandate. Your mandate sets out your responsibilities. If your mandate is silent as to maintenance, you have to add something in. You have to add in something that covers you for maintenance. If nothing else, if you're not even taking the responsibility that you can spend X amount of money, if that's not what you're doing, you at least need to have in your mandate something simple as to what your maintenance procedure will be. In the event of maintenance, we will report to you in this, and you have to advise us as follows. Something simple. Because, as I say, it's a real problem. And there's a lot of mudslinging that goes on here. You want to be able to say, I've done my job.
Yeah.
That's the important thing. This is about protecting agents and protecting landlords, but I know 90% of our people here are agents. And if a landlord, if there is a landlord listening and it's a landlord who doesn't do maintenance, all we can say is please do the maintenance. And when it comes to the agent, you don't control your landlord, protect yourselves. There we go.
I love that. Ishmael, I know there's exciting things that you have planned for the future. We are quite looking forward to it. Some amazing documents that's going to come available. And we will definitely have you available on one of our webinars again to share that information. I want to say thank you firstly from us. So before I jump and before Ishmael goes, I'm going to share his details now. Just to say, next month we have the Property Pulse webinar again on the 19th of March. Loan Hale, Jaco van Staden will be joining us on that day. He's one of our panel attorneys here in Gauteng. And we are going to look at the rental mandate unpacked. But there's a bit of a twist. I'm not going to do the standard mandate training. This one is specifically focused on the fact of it being completed correctly. And secondly, what happens when it gets cancelled? We are getting a lot of questions where agents are saying, yeah, but you can't cancel the mandate because it's my tenant. Or the one agent said to me, well, if you cancel my mandate, the tenant has to vacate. And I said, "So that's surprising." So I think it is just to touch on those type of things. So please keep an eye on it. We are going to share those details. But if you're in the Cape Town area, if you've got any matters, please, there's Ishmael's details. They are so responsive. I have to say this about, and I think that's why everybody loves working with Ishmael's firm. They are responsive. They give back an amazing service. So please reach out to them. If you're an Expelo client, as you know, Expelo gets a special treatment. I have to say this, they treat all their clients good, but they do humor us and say that you get special treatment, but they're always doing a fantastic job. Ishmael, thank you very, very much. I really appreciate your time and being available and all your knowledge.
Thank you very much, Elise. I thoroughly enjoy these sessions, and I look forward to the next one.
Thank you, Ishmael. Have a good day.
Okay.
Everyone, please be safe. Be good. We are going to start sharing more and more information. We are also very excited to announce we are also going to have, considering everything is going on WhatsApp, we are also going to have a WhatsApp group, because it seems a lot of our email correspondence with our events, our webinars, any information we're sharing doesn't always reach you on email. So we are going to have that WhatsApp available. If you, we are going to share the link. You are going to get invited. If you don't just leave. It's not going to be a communication one. It's purely to share some information. So reach out for that. And I want to say thank you to each and everyone taking the time. We are going to make this available on YouTube. So please go to the Expelo YouTube channel. All our webinars we place on there. All the information, all our guest speakers. There's a wealth of information on there. So please join, go to the YouTube link. We're going to make everything available. Thank you to each and everyone, and have an awesome day.